Hello, everybody. I know it's been a while. Happy winter solstice, the shortest day of the year. Yeah, now the days are going to be getting longer. Can't complain about the winter too much so far because we have had beautiful weather and no complaints. So I've got a few things to cover. And before I forget, thank you everybody so much for the cards and gifts and the emails and phone calls with words of love and support. We appreciate all of you so much. And I've got a few things to cover here. And first I wanted to cover the Perez case update because there was a public webcast of the oral arguments for the appeal that Abel Perez had done. And since it was a public webcast, I was able to record it. And stay tuned after the video. I will play it in its entirety. And I hope he will get a favorable hearing this time. And I mean, it's just the judge that was in the smaller court trial, it was so biased against him. And even tried to tell him that he should have known all along that he was abused. I mean, that is just, a lot of us don't even realize that what we went through was not normal. I'm a victim of physical abuse. I did not know it wasn't normal to be beat, and thrown against furniture until I was like in my 30s. And it's like, oh my God, I was abused. That's not normal. It's not. So it may take a while, and then for the judge to say that you should have known all along you were abused before now, and you know, it wasn't until he was an adult and later that he went to a psychiatrist, a therapist. So yeah, hopefully. But I do want to mention a few things. Now, the JW parents waived their right to appear at this oral argument. They chose not to rebut anything that he was saying. And that was interesting. And, you know, I don't know why, but, you know, you would think that you would want to show up to defend yourself and rebut what is being said. But we know that they were disfellowshipped for CSA. And the dad was an elder for many years. So to be disfellowshipped for that and not even deny it. And in the smaller court hearing, they never denied it. And also, he had already been accused of physical abuse when Watchtower appointed him an elder. And this is what is so crazy. And, you know, we know Watchtower hides this all the time. It's what they do. Now, I did hear from someone. Thank you very much, sweetie. I appreciate it. From the 2024 Elder School. I'll just read their email. I received information regarding demographics in the U.S. for the 2024 service year regarding elders and ministerial servants in the last week. Now, I also asked him if he had heard anything about the new Elders Manual or updated Elders Manual that was supposed to come out last month, November. And he said there was no mention of it and nobody has said anything about it. So at this point, we don't know. But this was interesting for the United States. Elders, percentage of the age of them that is 70 years old or older is 26%. That is the highest number. So the majority of them are over 70 years old. 61 to 70 is 22%. 51 to 60 is 20%. 41 to 50 is 19%. 31 to 40 is only 11%. 30 years old and younger, 2%. That's not good, because when these older ones start dying off, they're going to have even less elders. And we already know they're hurting for elders. A lot of these congregations are merging because they only have one or two elders. In fact, I got an email, thank you to the person who sent me an email from Australia, that a lot of the congregations are still merging. A lot of the kingdom halls are still being sold. There's a Facebook page that is Australian Kingdom Halls for sale. And they do all of this property. All of this property. Okay? Now, ministerial servants. Percentage. 60 years old or over is 36%. And that was the highest one. So that's quite old for ministerial servants. Are they even going to be able to serve as elders? Who knows? 50 to 59, 15%. 40 to 49, 15%. 30 to 39, 14%. Under 30, 20%. Now we know here recently in the past year or two, they have been encouraging to, work with the younger brothers in the kingdom halls. And if they are a regular publisher, not only can they handle mics, but you can appoint them as ministerial servants even in their teens. And elders can be appointed now even in their 20s. So, like we've mentioned before in videos, that reeks of desperation. I know it. Reeks of desperation. Now, I want to mention something real quick. I've had two people contact me. One contacted me yesterday, and they had sent me a screenshot, and their channel was taken down for repeated violations of the spam, deceptive practices, and scams policy. Because of this, we have removed your channel from YouTube. We know this is probably very upsetting news, but it's our job to make sure that YouTube is a safe place for all. If we think a channel severely violates our policies, we take it down to protect other users on the platform. And of course, you can appeal it. It says what our policy says. Content that promotes spam, scams, or other deceptive practices isn't allowed on YouTube. Now, the person asked me, any suggestions. I did help them, to appeal it, and I haven't heard anything back yet. Usually it takes YouTube at least a week or so if, you appeal it to give you an answer. And then, and I was busy doing other stuff, and I didn't think much about this one. And then I got another one from someone that said YouTube said that someone had filed a complaint against them. And I don't know if it's Jehovah's Witnesses or Watchtower. I don't know. Your guess is as good as mine. But we know those are the only ones that would want to come after any of us in our channels. But they said, scammers and deceptive information. And so I don't know what's going on. I haven't heard anything. I haven't heard anything from YouTube. I'm just very thankful that we have never asked for money. We have never had Patreons, and we always try our best to get true information out. But I bring this up because those of you that have YouTube channels, you might want to be careful. So I don't know, like I said, if Jehovah's Witnesses are, trying to come, or Watchtower is trying to come after our channels using, this tactic now about scammers, deceptive practices, and spam. So, I don't know. But anyway, you all have a wonderful weekend, and we're hoping, we've got a couple of videos in the works, and we're hoping to get them done before the end of the year, so hopefully. And if I don't see you before Wednesday. You all have a wonderful holiday and a happy new year. We love you. Bye.
Call the next case on the calendar, our case number 87666, Abel Perez versus Roberto Perez and Nina Perez. Mr. Abel Perez?
Yes, my name is Abel Perez.
Very good, sir. You've requested 30 minutes, and so
Yes.
there's a clock that you can keep track of, and we'll keep track of it too. We've read the briefing, and we're familiar with that, so please keep that in mind
Yes.
when you're addressing us. And with that in mind, you can proceed to the podium.
I made many points in my brief. I'm going to focus on 3 points today. And may it please the court, I will give a brief restatement of the facts to present the proper context for the points I wish to make. I originally filed a lawsuit based on sexual and physical child abuse. I did not proceed with the sexual abuse cause of action because the judge ruled only an attorney can file certificates of merit. The cost of hiring an attorney was prohibitive, so I proceeded with physical abuse as a cause of action. The physical abuse administered by Roberto Nina Perez was of an extreme sort. I starved much of the time and was forced to work for Roberto for no pay or food. Violence in the Perez home was a permanent fixture. Roberto Nina would drag my siblings and I by our hair and ears, whipping me while naked or in the shower. Assaults with leather horsewhip, wire hanger, and extension cords, punches to the face, and backhand attacks. I would like to make 3 points today. The first, this appeal hinges on whether my fourth cause of action for civil battery is within the statute of limitations. My cause of action was based on CCP 340.15, which gives 3 years from the date an injury in connection with physical abuse is discovered to file a claim. The trial court erred in its interpretation of CCP 340.15. It ruled I was outside of the statute of limitations because I have always known of the physical abuse. At age 8, I tried speaking up about the abuse. This was squashed by the church. Following this event, I began to internalize the abuse and use the coping mechanism of self-blame. I became convinced I was a sinner of low self-worth. Because I was raised in isolation from other children, I had no normal standard to compare my daily life to. Another coping mechanism I used to survive was denial. I denied reality by telling myself that I was fine. I denied reality to shield myself from the horror of my day-to-day reality, a coping mechanism I continued into adulthood. As an adult, I believed I had survived psychologically unharmed from my childhood. Roberto and Nina, by their words and actions, had convinced me their actions were normal parental discipline. They cloaked their actions under a facade of normalcy. In Riley versus Presnell, Riley was unable to immediately link his injuries to the abusive psychological treatment he was receiving because the psychologist was cloaking the abuse under a facade of normalcy. Children who suffer from abuse create psychological coping mechanisms. They unfortunately continue these coping mechanisms into adulthood, which then hinders them from properly recognizing the psychological harm that was done to them. Ironically, the very shield used to protect themselves as children now acts as a barrier to resolving the trauma. In Ross versus Garabedian, quote, the plaintiff's inability to link psychological harm to the defendant's conduct stemmed from unconscious coping or blocking mechanisms commonly found in victims, end quote. At age 18, I repressed all memories of my childhood. It took a decade to recover those memories, and it took several decades to build a sense of self-worth. Only at that point could I begin to make a connection between the physical abuse and psychological injury. The trial court's reasoning was that because I knew of the abuse, I reasonably should have connected the psychological harm long before 2019. Case law does not support the trial court's position. In Riley versus Presnell, quote, if an initially reasonable person, by reason of the experience forming the basis for the plaintiff's complaint, have his or her judgment altered in some way, such altered judgment then becomes the standard. The cause of action will not accrue until such an individual would have discovered the damage, end quote. The trial court's line of reasoning here was that, by their own definition, me, a psychologically damaged person, should have recognized I was psychologically damaged long before 2019. The trial court did not offer an explanation on this line of logic. The evidence shows the trial court was not even reading my court filings, much less be able to claim it could place itself within my subjective life experience. Two major events happened in 2018 and 2019 that caused me to question the reality of my coping mechanisms. One of them was getting married in 2018, and I was now living in intimate proximity with another person. Behaviors I had accepted as normal were now reflected back onto me. This culminated in the 2019 psychologist visits. Before 2019, I had never seen a psychologist in my life. Neither the trial court or defendant Roberto Sr. has ever presented evidence that I was aware of psychological damage before 2019. My cause of action for physical abuse was filed within the criteria set by CCP 340.15. The fourth cause of action should be remanded to the trial court. Second point I wish to make, this case was not disposed of on its merits. In the trial court's ruling, the judge admitted that I could potentially amend my complaint to show I was within the statute of limitations. The trial court then speculated I would not be able to present a suitable reason for not discovering injury until 2019 and did not allow me to amend. The reasons for not discovering psychological injury until 2019 is a material fact to be decided by a trier of fact. Douglas versus Superior Court, quote, California courts have a policy of great liberality in allowing amendments at any stage of the proceedings so as to dispose of cases upon their substantial merits, end quote. Because the trial court's judgment was based on speculation and a material fact was left unconsidered, the judgment sustaining demurrer should be reversed and the case remanded to lower court. The third point. Roberto Sr. as a pro se litigant was required to conduct his own defense. We have a sworn statement on page 11 of the respondent brief from his son Robert Michael Perez stating he created the appeals response document while acting under the alleged authority of power of attorney. Roberto Sr., as a pro se litigant in this matter, was obligated to personally prepare and file all pleadings. The submission of a respondent brief prepared by an individual claiming to be operating under the alleged power of attorney undermines the fundamental principles of self-representation. Such conduct should not be overlooked because it risks compromising the integrity of the judicial process. This case should be remanded to the trial court. Any questions?
There are no questions, sir, but thank you for your argument. Anything further?
No, thank you, Your Honor.
Good, thank you. Matter will be taken under submission and we'll notify you at the appropriate time.
Yeah,
Thank you.